And we're back in the Judiciary Committee taking up H53, turning to a different bill that we have not had the opportunity to look at yet this session, but certainly one that we'd like to move along. And we're going to hear from Legislative Counsel who will give us a walkthrough. So, Cynthia, please. It's great to see you.
It's great to see all of you.
It's been a while since you've been in Judiciary.
Yes, I don't think I was here at all last biennium. This really is the only topic I come in, except sometimes for bicycles and biking under the influence.
We were hardly here last biennium.
Blur together. So for the record, Anthea Dexter-Cooper from the Office of Legislative Counsel. I provided your committee assistant, who has posted and I believe printed out two documents. One is H53 as it was introduced, and the other one is just an updated history of some of the efforts that the General Assembly and the Judiciary has taken with respect to driver's license suspensions. I wasn't planning on walking through that, but I certainly can give some of the highlights if that would help the committee sort of frame your discussion. So I will take direction from you.
I think it would be very handy if you kind of gave us a little history of what we've been trying to do.
Sure.
This is like building on of what we've been doing over the last 7 years.
Certainly. So I'm going to work off my handout, and I'm not going to go through all of it. I'm going to do the highlights of the highlights. So going back to 2012, there was the Nonviolent Misdemeanor Sentencing Review Committee report, and one of the things that it recommended was to create a civil driver's license suspension diversion program and have that be a means of dealing with license suspensions as opposed to having them go to the Judicial Bureau. That was created in 2012, Acts and Resolves number 147 in section 2. Section 4 of that bill also amended 23 VSA section 2502. That's where you get the point assessments in statute for all of the moving violations, to eliminate point assessments for 23 VSA section 674 and 676. And these are the two driver's license suspension statutes. And what that did was it made it so that those violations, so driving with a suspended license, is no longer a moving violation. Moving violation is defined in Title 23. What I have pulled up for you is an excerpt from the DMV's violation code chart. And you can see 674 in the middle there. It used to be 10 points. That yields a suspension under the suspensions that are possible for point accumulation. And you'll see that it was 10, and then after 7/1/2012, it was 0. If you are ever wondering if a violation is a moving violation, look to the definition in 23 VSA section 4, or you can find all of them on this chart. I think the chart is incredibly useful. In 2014, there were some amendments to 4 VSA section 1109. We're going to be looking at that when we turn to the bill. Over time, the suspension language, which was originally in Title 4 and Title 23, all merged over to Title 4. And it was amended to substitute a suspension for reporting delinquent traffic violation payments to credit bureaus. So I would say that was a shift more in the direction of having not paying a ticket leading to suspension as opposed to just owing money. 2014 also made some changes to language in Title 23 to extend time to pay judgments on traffic violations, to cap the length of suspensions at 120 days. So in 2014, it was a shift down to say your license can only be suspended for 120 days for not paying a traffic violation, and only have judgments owed against a sole vehicle registrant lead to having your registration be denied because you had tickets that hadn't been paid. Some of those things have since been shifted even lower or eliminated, but that's where things were in 2014. In 2015, there were 2 driver restoration days. One was in Chittenden, Franklin, Grand Isle, Lamoille, and Washington counties in March, and then one was in December in Windsor County. Those were done by then State's Attorney Donovan and some of the other state's attorneys. That was not something that was implemented by the General Assembly. In 2015, the chairs of House and Senate Judiciary requested that there be a working group on trying to approach or come up with approaches to reduce the number of people who had a suspended driver's license. That yielded the Driver's License Suspension Task Force report and an act in 2016, which was the last really big set of changes to the license suspension laws. So Section 1 of that 2016 Act terminated certain suspensions that had been outstanding since before 1990 for failing to appear. It created an extended one-time driver restoration program that went for all of September, October, and November. And there was a report that was required after that. I have a link to the report here. Section 3 of that act terminated suspensions that weren't related to driving conduct. It was if you had underage alcohol, that was something that used to yield a license suspension. I believe before this, there had been a repeal for when littering could yield a license suspension. So this was shifting more in the direction of saying suspension should only be related to driving conduct. Section 4 repealed the then permissible having your registration renewal be denied for having an outstanding traffic judgment. And then it shifted all of the language that had been in Title 23 over to Title 4. Some of it was accidentally not moved. The first one was under law up to 2016, the Judicial Bureau hearing officers could waive the $80 reinstatement fee that was required after your license had been suspended. So even if you had paid it, your license would still be suspended until you paid that $80 reinstatement fee. That was fixed in 2020. That's the very last thing on this handout. So that was something that was corrected a few years later. I believe that was an inadvertent repeal. Another thing that Section 5 did.
Was it inadvertent?
I think it was done inadvertently. It was something that was included in the miscellaneous motor vehicle bill in 2020 as we're fixing this. I think it was just an oversight in 2016. And then this one's really big. The second bullet point under Section 5, it switched from saying that a traffic violation for which you had an outstanding judgment could lead to a suspension to a traffic violation for which points are authorized. So that's saying it's not all traffic violations that you don't pay that lead to suspension, but it's the ones that are moving violations. So again, going to this chart, it's only, and this is current law, if you have a judgment against you, it was a moving violation that put points on your license that you didn't pay, it's going to lead to suspension. The points are always really important because for senior operators, it's different for junior operators. Once you hit 10 points, your license is suspended, and then it goes up from there. And that's on a 2-year rolling basis. So the points will fall off your record. The last big thing that 2016 Act did related to suspensions was it reduced that length of the suspension from 120 days, or you paid your owed judgment, to 30 days, or you paid your owed judgment. And that's where the law is right now. The 2016 Act also required reporting of statistics that I think you probably can hear more about from the DMV, and there are reports from the calendar year data, 2016 through 2020. And it shows there have been changes in the number of license suspensions, but I think that that's data that can be looked at to try and determine if efforts are working to achieve the goal, if the goal is to have fewer people having their licenses suspended for things related to non-payment as opposed to your behavior on the road. So that's like an overview of, like, when did I go back to? Of 10 plus years of efforts here. But the last big thing was in 2016, aside from that correction in 2020. And the current state of the law is licenses can be suspended for things related to driving conduct. And then the only reason that your license can be suspended for non-payment is the non-payment of a moving violation. In H53, the main thing it proposes to do is change that.
Before you go, I just want to make one comment on this, that in 2020, I don't think I ever had a bill introduced with you, but I think I started talking to you about coming back and looking at this, and then kind of COVID hit. People weren't driving, and it's kind of fell off the radar a little bit. But the idea was to start looking at, where are we? And I was really prompted to look into this last summer when I was at a conference regarding fees and fines, and how a big part of that was how fines and fees leading to suspended license was really not a very good thing. And then ended up that Karen was also introducing the bill as well. I don't know if you give just a little background kind of as a lead sponsor and why you also, because that's why I kind of wanted to push this year. But.
Yeah, well, through my work at the Community Justice Center, we would come across a lot of people that were trying to get to work, trying to just get through their life, and they would kind of rack up these driving while license suspended. So they're like, I'm trying to get to work, and so it was this thing of wanting them to be able to work and get through their life, and they were also not having the money to pay this off. So it was, how can we work through this? And so, like seeing as it wasn't their driving behavior, it was just the fact that they couldn't pay that was preventing them from being able to do that.
Anyway, I just want to give you, and Barbara, you've been part of these things for the last 8 years too.
I have, and I sort of morphed in a different direction on them, which piqued my interest when and I just want to make sure I'm clear on people who get their cars towed for not paying certain fines. And so you mentioned something about registration. So if you could just sort of say what the state is related to registration.
So that has been repealed, the language that said that if you didn't pay, if you had an outstanding ticket, it wouldn't let you register your vehicle. And for purposes of, if there were to be a traffic violation related to parking somewhere where you weren't supposed to, leading to your vehicle being towed, that wouldn't be a moving violation. So that's not going to be one that not paying would lead to suspension.
So somebody who has outstanding tickets can get their car re-registered, but depending on where they live, their car may be towed for having outstanding tickets.
Yes. So
But that's not statewide, or that is statewide.
I do not think there is anything in Title 23 that addresses having your vehicle be towed for non-payment of traffic violations, including moving violations or parking tickets.
So that's
I think that's a municipal.
right. And I know we have had discussions about Burlington, given my constituents, but
I will check on that, but I do not think there is anything in Title 23.
It's a practice. You can't operate an unregistered vehicle on a public highway, so they remove them.
That is accurate. Your vehicle needs to be registered to operate it.
right. But yeah, okay.
And
So I just-
lots of times it boils down to a discretionary thing though, too. Just put it in this parking lot until you take care of it or whatever, but.
Okay.
Right. Okay.
Thank you.
And one other thing, Representative Wand, you reminded me, in 2020, this committee did vote out a bill that changed when you need to have the SR 22 certificate, and that's sort of the extra proof of insurance. So you did address a piece of the problem that people were having with respect to having the money to pay to legally be able to drive.
This is the next step. So if you could give us a walkthrough of the bill, that's great. Thank you.
Okay, so H53, there is a lot of pages here to do one main change, and a lot of what's here are technical corrections that are also going to be done in the technical corrections bill once that's introduced. Starting on page 1, on lines 18 and 19, this is a subsection heading, so it's not the law, but it's providing the readers with sort of a short explanation of what this entire subsection is going to be about. And these two lines are changing that because there's no longer going to be suspensions for non-payment of certain traffic violation judgments. And instead of adding payment plans, be more descriptive of what is happening in the balance of the subsection. Page 2, lines 6 to 18, this is the heart of the bill. This is what is eliminating the suspension for non-payment of those certain traffic judgments. Sometimes I think it's really hard to see what's being struck out. So it's up on the screen. And current law says that if there's a judgment on a traffic violation, that there can be points, so moving violations, against someone's driving record. The judgment needs to contain notice that failure to pay or otherwise satisfy the amount due within 30 days of notice will result in a suspension of the operator's license. That's being eliminated because if you don't have suspensions, you don't need to give notice that there's going to be suspensions. It's then deleting the fact that if the defendant fails to pay the amount due within 30 days, and this is the process that yields the suspension, or by a later date, then the Judicial Bureau needs to provide electronic notice to the Commissioner of Motor Vehicles. And then after 20 days from the date of receiving that notice, then the license will be suspended for a period of 30 days or until the amount due is satisfied. So by striking out all of current subdivision 2A, you see on the screen, and what's struck from line 6 to 18 in the bill, you are eliminating suspensions for the non-payment of moving violations. The next revisions that you see at the bottom of this page is our technical, eliminating the subdivision B designation because you don't need it anymore, and changing a person to an individual, just the way that statute defines a person. It can be more than just like a human being, and it's only human beings that have driver's licenses. It's then taking out the instances where a payment plan needs to be offered, because under current law, a payment plan only needs to be offered in order to avoid suspension. This would be allowing payment plans in any instance, not just to avoid suspension, because it's in the earlier deletion, eliminating those suspensions. Nothing about the payment plans change. It's still $30 per month, not to exceed $100 per month. Another person to individual change on line 2, some technical corrections with the subsection and subdivision headings on lines 3 and 4. Again, all of these are going to be included in the technical corrections bill. They're not intended to be substantive. I would say lines 5 and 6, the addition of the things that need to have happened or not happened before there can be a civil contempt proceeding for the non-payment to try and collect on that. Then it doesn't currently include in law that the defendant is not currently complying with a payment plan. My guess is that there are not contempt proceedings if someone is complying with a payment plan. That might be something that you would want to confirm that practice is matching what it seems like the logical practice should be. But this is putting into statute that if someone is complying with the payment plan, there shouldn't be those civil contempt proceedings that are starting. Everything else in this bill, from line 8 on page 3 until section 2, the effective dates, are all just technical corrections that are not related to the purpose of this bill. If you removed this, it would all ended up being corrected in the technical corrections bill anyway. But what happens in section 2 is important. This is your effective date section. This is saying that the effect takes effect on passage, and then providing some explanation of implementation, and that there shouldn't be any license suspensions from that point forward. So even if there was a violation that took place before the effective date, if you don't pay it, it's not then going to lead to a license being suspended. You could change that implementation, but I do think you need to provide, if you move this bill forward, some clarity as to how the timing of things works.
Sure.
So there are no suspensions going forward. If there's a violation that could lead to a suspension, what about people who already have their license suspended because of that?
This bill doesn't change that. Okay. But there have been efforts in the past. There was definitely one in the 2020 miscellaneous judiciary bill that eliminated certain then existing suspensions. It would be a question for the DMV as to whether or not that is a determinable universe to say anyone with a license that is currently actively suspended solely because of non-payment of a traffic violation, that suspension is eliminated. And remember, these suspensions for non-payment under current statute are capped at 30 days. So it could be that the rollover factor makes it so that it's not something that you would need to address if you were not concerned with a suspension that's not more than that. 30 days.
30 days it would roll over.
Yeah.
And then they couldn't get another one. Because I feel like that's what I see happening is people just keep getting the DLSs over and over.
And there are still, and this doesn't change that, the tiering of, so the building of, if you are hit with a certain number of driving with a license suspended, then your license can be suspended.
Yeah.
In existing statute.
Barbara?
So just to make sure, like, we're super clear on both sides of it. So it's good to know that the things that we're not addressing on the moving side are the two that you just mentioned, the people that currently have their licenses suspended or having the exponential.
It also doesn't change the fact that if your moving violation is getting you to having 10 points, your license is still going to be suspended under the approach to license suspensions unrelated to ability to pay, but related to what you did to get those points on your licenses to begin with. I will say that that first suspension at 10 points is less than the 30-day suspension for non-payment.
So can you just, for the sake of peace of mind for me, talk about the status quo for people that have non-moving because we're talking about moving, so non-moving violations. What can happen to those people right now? I just think it's important to understand.
There still can be the attempt to collect the money that's owed, and that is something that's addressed in 1109. It can go to a collections agency, there can be contempt proceedings, but in that instance, it's money that's owed for like an equipment violation, not money that's owed for a moving violation. So there's that different treatment, but it is still, you owe money, you have a violation, it is outstanding.
And so there's still attempts to collect it. And do we differentiate?
I will say that statute says that they can collect. I do not know, and this would be a question for the judiciary, what efforts are actually being done to collect that money, what it's yielding, how much it costs to collect a low ticket price.
Is that just for state, again, do these laws just apply to state violations? We're silent on municipal violations or what we allow municipalities?
So if a Burlington police officer is writing a ticket for speeding, it's a state violation.
Okay.
I do not know if there are moving violations on a municipal level.
Right, okay.
I don't know if there's been any delegation of authority to municipalities to have that. Municipalities are able to regulate things like parking and the use of the streets. I don't know of anything that has been delegated to say that they can regulate.
But so for the non-moving ones, are they bound by that language that you just quoted about attempts to collect or efforts to like?
Well, this is the Judicial Bureau collecting.
Right, this is just the Judicial Bureau. This is not Vermont, just collection.
Yes,
Okay.
correct. And
Just
your license, your privilege to operate, that's coming from the state. It's not coming from a municipality. So that's not something that a municipality has regulatory authority over.
no, I'm just again thinking about if you don't have your car, it doesn't matter if you have your license, but I
think the things that are going to lead you to not have your car are related, but not overlapping completely with the reasons why you might not be able to legally operate a car. And this is what you might do to have your license be suspended without regard to whether or not you have your vehicle still or you want to go rent a vehicle.
Right. Okay. Thank you.
So, just a couple questions. I just want to, there will still be all the other remedies, obviously, to collect the fines, right? As far as for the moving violations and stuff.
Nothing about that's changing.
Yeah. And there are a couple other places where somebody will still be able to have a suspended license. That's failure to pay childcare, looked into and really can't.
Childcare?
Child support.
Child support.
Okay, all right.
Child support.
I was like, childcare, awesome.
It's so in my head.
I just double checking, sorry.
And that's a federal requirement that in order to get federal money, yeah.
And also DUIs.
Yep, DUIs, nothing changing there, nothing with the accumulation of points leading to suspensions. This is just the non-payment piece.
Okay. I think that's covers it very well. I appreciate it.
May I ask another question?
Yes, please, Karen.
So this is changing if you don't pay the moving violation suspension, it is not changing the fact that if you accumulate points, your license would be suspended.
So two things for me. So like the piece that I get from this is that this really is aligning suspensions with your driving behavior, not for availability of funds.
It's splitting the approach. So right now, if you don't pay the moving violation stemming from driving behavior, there are two paths that can lead to your license being suspended. The fact that you accumulate points and the fact that you don't pay a ticket. This is taking away that second branch, just the accumulation of points.
My question is, because you brought up I think the criminal DLS piece of this is, so these are all under DMV, these are civil incidents. But it is, I forget how many it is, but you accumulate so many DLSs and then you get a criminal
one, yeah.
DLS, which again is this huge cycle that people get stuck in. So this would be eliminating from this. But I think you were saying that if we are able to capture that group of people that might have DLSs, if this was to go into effect, like those people would still have that count towards their.
Well, if their license was never suspended for the non-payment, then it wouldn't be a suspension that could lead to that tallying to hit the criminal.
Okay.
So it's still not going to change the fact that if you accumulate points,
Yes.
that's going to be a suspension that can build towards that
Yes.
count.
Yes. Okay.
Is it 5 DLSs
I thought it was
that criminal? Or it's 6? I know they've changed that around over the last 20 years, but
It changed in 2016. I think before 2016, I would need to go back and check, the 6th or subsequent if the 5 prior occurred after July 1, 2003. And now it's the 3rd or subsequent if the 2 prior were within 2 years and after the December 1, 2016.
so I think that the concept there, as I recall, is it was maybe reduced because we're thinking we're going to have as many suspensions because of non-payment.
It was also making the drop-off window smaller. So if it was the 6th or subsequent, if there were 5 after July 1 of 2003, that was giving you like 10 plus years where you could be accumulating those suspensions. This is now the 3rd in 2 years.
Right, okay, right.
So shorter window, and if there are fewer suspensions, fewer suspensions.
I mean, part of this effort is to reduce the criminal suspensions, to reduce cases going into the courts or into diversion. And this is one avenue where we can reduce the number of licenses that are suspended. But I had a question. So and this will be a data question for DMV, but I'll ask you. So if DMV were able to determine that an individual had a criminal record because of DLSs, that the DLSs were because of failure to pay, that we could, let's open up expungement to them as well. I didn't mean to trigger anybody by saying expungement, but it's.
Can't use that word ceiling.
Yeah, well, sealing. I'll say sealing. I'm all good. I'm good with sealing. It's just what you can do with sealed records. Any event, but I have to think that'd probably be impossible to tell. But from your knowledge of DMV kind of record keeping.
I'm going to say, talk to the DMV. It might tell you that, we can't with our current computer system. So
Right. I've heard that a lot in 2015 and 16. They haven't fixed it yet.
they are getting $20 million to do a phase of fixing it. So yeah, getting upgraded computer system.
All right. So there's probably, I guess, there's not much that we can do going backwards.
I don't know.
For those people who may have DLSs based on failure to pay.
I do know, and I didn't re-look into it, and I actually took it off the handout, but there was something in one of these bills where the DMV then had to say, we just can't track that in our computer system, so they had to come up with a workaround. And there's a law enforcement bulletin for one of the efforts that was included in one of the bills that I have here.
That was clearing some really old ones, if I read.
Yeah, and I think it was something in 2013 where the DMV. So again, I think that they can give you lots of information about what the capabilities are of their data.
This afternoon about that. So any other questions for Anthea? I see none. So nice to have you back.
So nice to be in here with you. Let me know if there's anything else.
Yeah, absolutely,
Or
absolutely.
forfeiture.
I'm sure that, we're gonna try towing at some point. Yeah, so I have one other thing before we then break for lunch. Coach, we voted on H45. Do you wanna call his, do you wanna finish calling the roll?
Oh, bless you, my son.
We're still live.
Thank you for that reminder, late. So
We're doing sound of records.
this is H45, we voted. We're waiting for you. So I'll call your name now, Mr. Christie.
Yes.
Bless you. 11-0. If anybody,
Wow,
Someone's keeping track.
11-0.
All right, so we do have witnesses
Kate's
at
turn.
1:00. Once again, I'm hoping that we get started right at 1 because I know some folks need to leave a little early and I'd like to get our witnesses hopefully done early so everybody else can leave